Okay, aloha everyone. Welcome to the Board of Land and Natural Resources oral arguments held in Hilo, Hawaii. It is February 12th. Here we are in the Hilo County building. First of all, I want to thank the kupuna who came and pikai'd the room at the beginning. I'm sure that the intent really was for the cleansing of everyone in the room. So I appreciate that. Mahalo to the Hawaii Island County offices for allowing us to have this hearing in this room. I want to remind people in the audience that this is oral arguments and it is not public. It's not a public hearing, so we won't be taking public testimony. It is the petitioners in the contested case hearing for the Conservation District use permit that are to be heard today. So I just wanted to make that very, very clear. The order is the University of Hawaii will present. If they wish, they can reserve some time for rebuttal, and then the petitioners will present, and then we will close the if there is rebuttal, we'll hear rebuttal, and then we will close the hearing with decision-making to be done at a later time. So with that, aloha. We'll start with Tim Lui Kwan.
Aloha, Jermaine. Aloha, Chairman Aila, members of the Land Board. May I sit? Presenting, thank you. My name is Tim Lui Kwan. I'll be presenting the final arguments for the applicant, University of Hawaii at Hilo. With me today are other members of our legal team. I have Ian Sanderson on my left and Jay Hanlon on my right.
Excuse me, Tim.
Yes.
One other piece of information that's important is each side is going to be given 30 minutes to present. Do you want to reserve time for rebuttal at this time?
Yes, I would like to reserve at least 10 minutes of my 30 minutes for rebuttal. If the timekeeper can actually prompt me at 15 minutes and again at 20, I would appreciate it.
Okay, shall do so. So your time begins now.
Okay, thank you.
If you can keep your voice up a little bit.
Okay, Gene, how's this? Is it okay? Okay, thank you. Also with me today is University of Hawaii at Hilo Chancellor Dr. Donald Straney and Ms. Stephanie Nagata, who is Director of the Office of Mauna Kea Management, or OMKIM. We'd like to thank the board and the department staff for coming to Hilo today to hold oral arguments in the contested case hearing on this application for the construction of the 30-meter telescope, more easily referred to as the TMT. It has been nearly 2 years to the day, or just a fortnight shy, since this board issued this preliminary ruling on the TMT application, ordering the holding of this contested case. Proceedings in which the parties were put to their proof in providing credible evidence supporting their claims, and ultimately their position on whether a conservation district use permit should be issued. However, the evidentiary proceedings before the hearing officer is done, and the parties are here today to provide you with a summary of the legal reasons why they should prevail, a summation of the evidence and the legal authority. Well, an important part of the due process, oral argument is not evidence. It is only argument. It's important to keep in mind the scientific and educational purpose of this project, which is considered when completed along with the Large Hadron Collider constructed at the CERN project in Switzerland to be one of the two greatest scientific achievements of this century. As noted by Professor Michael Bolte in his testimony, the study and observation of the universe is the oldest of the exact sciences that stretches far back into man's prehistory. Astronomy is one of the first subjects recorded in historical accounts by the planet's earliest literate civilizations. In ancient Egypt, the date for the annual flooding of the Nile was predicted by the heliacal rising of a star. Their observations of the heavens also tell the Mayan kingdoms of Central America when to go to war, and the Chinese when to start their new year, Kung Hi Fa Choi. Our earliest unaided observations allowed us to measure time, when and what to hunt, gather, and plant. Later, the study of the stars and planets took us to far places on countless journeys over trackless expanses and made it possible for us to navigate our way home. It has seen the rise and fall of every great civilization and witnessed the creation of all the world's religions, often providing the foundations for the religious beliefs and cultural practices. And its believers with proof that a universe so large and complex could only be the work of God or gods. So intertwined in our history was the study of religion and astronomy, the science of astronomy, that it was not separated in the West until the time of Galileo and Newton. In the present, we find evidence of our origins and that of the universe, which is the totality of all space, time, matter, and energy. As described in the application and confirmed by the evidence submitted by the applicant during the hearings, the TMT is not just another telescope. Its segmented primary mirror spanning nearly 100 feet will be 10 times more powerful and far more advanced than the largest telescopes in operation today, the twin Keck telescopes in Mauna Kea, allowing us to see farther and with more detail than anything in operation. Once the TMT is operational, it'll be the first in the next generation of giant telescopes that will seek the answers for questions on the nature, origin, and composition of the universe, and whether there is life elsewhere out there. The selection of Mauna Kea as a site for the construction of the TMT is essential if Mauna Kea will continue to be the world's best ground-based viewing platform for astronomy. After considering 6 possible locations in Chile, Mexico, and Hawaii, it was determined that Mauna Kea's viewing conditions, its high altitude, atmospheric clarity, relative darkness, together with the accessibility of the Mauna Kea Science Reserve and its outstanding support facilities and infrastructure, and neighboring observatories and a supportive local community made the selection an easy choice. Its location on the mountain's northwestern plateau was identified in the 2000 master plan. Is best suited for this type of observatory at a lower elevation and less visible than the other telescopes within the precinct, while avoiding the most sensitive areas in terms of Mauna Kea's natural and cultural resources. The location selected provides additional mitigation while providing access to a spectacular night sky, another precious resource of Mauna Kea, allowing the TMT, in the words of Professor Bolte, a wonderful union to the universe. Current investment in astronomy in Mauna Kea is close to $1 billion. However, the investment of the TMT project and other supporting services is expected to more than double that by the time the facility is completed. The project will be an enormous benefit to the public welfare and bring significant monies to the local economy, as well as contribute new programs and funds to Big Island schools. Moreover, these benefits have been vetted and discussed with the community and at all of the public meetings during the planning process. As described in the record, the TMT project will provide employment and educational opportunities for Hawaii in a clean, high-tech endeavor that will be a source of pride for the community while advancing our understanding of the universe. Petitioners here have been involved in the planning process long before the submission of this application in September 2010. However, they now claim that they've been denied due process in these proceedings. The truth is that most of the same petitioners have been involved in the planning process from the very beginning, even bringing a challenge to the board's adoption of the Mauna Kea Comprehensive Management Plan, the CMP, and its subplans, though resulting instead in the Intermediate Courts of Appeals affirmation of the board's action and process in approving the CMP. Petitioners have had an abundance of due process, and they have had more than ample opportunity to prove their claims that the board's criteria for issuance of a CDUP for the construction and operation of the TMT has not been met. They submitted testimony at the public hearing on the application. They fully participated in the contested case hearings held over a 6-month period in 2011, as reflected in the proposed findings of fact and conclusions of law. What the petitioners experienced was not a denial of due process. It was a failure of proof to support their claims they argued vigorously, repeatedly. In truth, they would oppose any further telescope development, no matter where placed within the astronomy precinct, and no matter what manner of construction. The board delegated to the hearing officer the responsibility to hear, review, and consider evidence offered by the parties in support of their respective positions. His proposed findings and conclusions should be afforded considerable deference, as he was able to assess the credibility and demeanor of the witnesses during the testimony and weigh the evidence submitted in proof of their claims. The applicant supports the finding and conclusions proposed by the hearing officer, subject to a few suggested additions and changes as set out in our January 9th, 2013 exceptions. As noted in our exceptions, it is the university position that findings and conclusions proposed by the hearing officer on November 30th, 2012 are overwhelmingly correct, but feels that several areas require clarification to more fully and clearly reflect the proceedings. The proposed exceptions seek more clarification rather than substantially modifying the hearing officer's proposed determinations. While these suggestions are detailed in our submitted exceptions, I did want to outline several, including clarification of the scope of this board's action on February 25th, 2011, which was not the board's final action on the application, in light of your simultaneous ordering of a contested case on your own motion, and the board's imposition of Condition 21, prohibiting any construction unless and until a final decision was rendered in favor of the applicant at the conclusion of the contested case. The applicant further suggests that the proposed conclusions also reflect the Hawaii Supreme Court's intervening decision in the State v. Pratt versus Pratt that was handed down and decided in 2012. The holding in Pratt is relevant to the issues in this contested case, as the Pratt court confirmed that even if all three elements of the Hanapi test are met, the privilege for Native Hawaiian customary and traditional practices are not absolute and may be subject to reasonable state regulation. The Pratt court directed that claims of right must be considered within a totality of circumstances, where there must be a balancing of the state's interests in the subject regulation to the right of the individual in the exercise of particular practice. The other significant exception suggestion is an exception to the proposed findings and conclusion that accurately reflects the petitioner's failure of proof of the first prong of the Hanapi test, as petitioners did not submit direct testimony or specific evidence that they are, quote, descendants of Native Hawaiians who inhabited the Hawaiian Islands prior to 1778. This is a specific evidentiary requirement set out in Hanapi, Pash, and Pratt. All three cases talk about the evidentiary requirement. While several of the petitioners testified that in fact they were Native Hawaiians, none submitted testimony and evidence demonstrating descent from Native Hawaiians who inhabited the Hawaiian Islands prior to 1778. The hearing officer correctly found and concluded that the TMT project satisfies 8 criteria of HAR, Hawaii Administrative Rules, Section 13-5-30, subsection C. While petitioners claim that all 8 criteria must be satisfied in issuing the CDUP, the argument is pointless, as the hearing officer correctly concluded that the criteria, all the criteria of subsection C are actually satisfied. The hearing officer concluded and correctly that the project was consistent with the purpose of the district. The Conservation District, as one of the specific objectives of the district, is to conserve and protect important resources through appropriate management. This is exactly what has been accomplished in this project with the adoption of the TMT project plan that is consistent with the state's CMP for Mauna Kea. The management plan specifically and thoughtfully addresses Mauna Kea's natural and cultural resources, including the environmental factors that make Mauna Kea arguably the best place on earth to put telescopes. The express purpose of the district rules is to regulate land use, not to prohibit land use as claimed by the petitioners. Hearing officer also correctly concluded that the project is consistent with the objectives of the resource subzone, as astronomy facilities are expressly permitted in the subzone under an approved management plan. And again, under subsection C of the criteria, the hearing officer correctly found that the project complies with the guidelines and provisions set out in HRS Chapter 205A of the CZMA. This is the only CZMA objective for the project which concerns the protection of water quality. The applicant's witnesses provided testimony that the project has been designed so that wastewater and pollutants would not be released into the surrounding environment. Petitioner's assertion that the TMT would undermine important view planes, destroy areas of historic importance, and increase the risk of water pollution were considered and rejected by the hearing officer. The hearing officer was responsible for weighing the evidence and assessing the credibility of the witnesses. The hearing officer also concluded that the project would not cause substantial impacts to existing natural resources within the surrounding area, community, or region. And we've detailed in considerable detail the reasons why he correctly found that. He also correctly concluded that the proposed land use is compatible with the locality and surrounding areas. While petitioners admit there are numerous observatories visible from the project and its surrounding areas, they wrongly contend that the project must reduce the cumulative impacts created by existing facilities to lessen substantial, significant, and adverse. This was rejected by the hearing officer, who concluded that the project had satisfied this criterion. Under the next, the hearing officer found that the project correctly found that the project preserves and improves upon the existing physical and environmental aspects of land. Petitioners interpret this to prohibit adding any structure where none currently exists in the subzone, even where the regulations expressly permit astronomy facilities and other structures under an appropriate management plan. To conclude that this criterion must be interpreted to literally mean that nothing that can be built on any part of the district would lead to an absurd or unjust result. This was rejected by the hearing officer, who concluded that this criterion was also met. Hearing officer also found that there would be no subdivision of land utilized to increase the intensity of land uses in the conservation district. The reason for this is the applicant is not seeking a subdivision of land, nor is one being granted by the board. Even if we were seeking one, government agencies and agencies of the state and the counties are not subject to that provision of the HRS cited by the petitioners. Legally and factually, there has been and will be no subdivision.
15 minutes.
Thank you. Petitioners also presented no credible evidence of any detriment to the public health, safety, and welfare in Mauna Kea. He found that the university's experts and evidence were more credible and in rejecting the petitioner's claims. And I would like to thank the board again for the opportunity for the summation of the applicant's position that the proposed findings of fact and conclusions of law are correct. If the exceptions suggested by the applicant in our January 9th, 2013 submission are also adopted by the board, I wanted to recognize the patience and effort of the hearing officer in conducting the contested case proceedings. I would also like to note the conduct and performance of the petitioners and what has been a long and sometimes tedious process. The parties have all acted professionally and respectfully towards the hearing officer, the applicant, and each other, and I commend them again for this. I would like to reserve again the remaining time that I have for rebuttal. Thank you very much.
14 minutes.
Thank you.
Thank you, Mr. Kwan. Next petitioner up is Kinohi Neves for